How can pro se defendants in small claims debt collection cases settle their debt for less than their lawsuit amount? That's the topic for today. Welcome to the Lawyers and Mediators International Show and Podcast by instantmediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Hi, I'm Mac Pierre-Louis, attorney, mediator, arbitrator, working throughout Texas and Florida.
And I am Natalia Łowska-Czajka, advocate, mediator, and arbitrator from Warsaw.
And I'm Tye Bourdony, full-time mediator and primary mediation trainer in Orlando, Florida.
Be sure to check out this show and podcast on YouTube, Apple Podcast, and Google Podcast, and on the Instant Mediations app. Remember, nothing said on this show constitutes legal advice, so talk to a lawyer as cases are fact-dependent.
All right. Thanks so much, everyone. So, Tye, we're back for another segment. This time, we're going to be focusing again on small claims debt collection cases and how to get them resolved, possibly through mediation. But you're one of the big gurus in this. This is why we like to have you on to discuss this. So let's say there's a typical scenario where somebody gets a hospital bill or somebody gets a, Chase Bank or Bank of America credit card, and they max it out and they are now being sued by a company, by the credit card company, and they might have outsourced it to a lawyer. The lawyer's coming after you. You get freaked out, you get served. Now you're in small claims court and they're trying to take a judgment against you to get that money. How can a defendant, or in Texas, we will call them a respondent, well, that's a family law, but how can a defendant in small claims debt collection cases then try to settle their cases for less than the amount they're being sued for?
Right. So typically I'm talking small claims court, right? And so when I was the staff mediator, when we did small claims court, the majority of cases were debt collection cases. So typically they're unsecured, credit that for one reason or another, the parties, stopped paying. Interestingly, you said a couple of different things, right? You said hospital bills, and then you said, some unsecured, credit lines. Sometimes those are a little different. And what I mean by that is, so, you get credit and you don't pay. And so then you go into collections and then they try and come after you internally for a while. When they can't 6 months or so, right, get you, then it goes to the next department. And then after that, it will typically be sold, right? And now, so a lot of, not every time, but a lot of the debt collection cases that I see were being brought by third-party debt collectors, right? So they've purchased it after it's already been written off, and they buy it for pennies on the dollar. Now, a lot of the unsecured debt can be that, but that doesn't mean all of it. Some of it can be brought by the first party, the party who you actually originally contracted with. So that might be a little tougher to settle, but regardless, the fact of the matter is that if you want to, one of the easiest ways to get rid of this, where the parties can actually save a lot of money, is by trying to settle it, right? Whether it's before you mediate, right? Because in Florida, you're getting sued, then you get served, right? And then you're told for small claims, everyone has to go to mediation. Things above small claims, they don't have to go through the ADR department at the courthouse. But below small claims, and that's currently, right, we're talking about like $12,000 to $15,000 and under, they're going to go to small claims. They have to go to mediation, right? And so you're going to get notice, you're going to get served, and then you're going to get something ordering you to go to mediation. Okay, now I'm talking about my jurisdictions can be a little different from jurisdiction to jurisdiction, state to state, country to country. But the fact of the matter is, that you're going that day to mediation. And a lot of times, first you go to mediation, and if it doesn't work out, then you go right to the judge. In my jurisdiction, if it didn't work out, you were given a date to come back. Regardless, now you have to go this day. The question is, what do you do? So always, always, always consider talking to an attorney, right? These are the kinds of cases that if it's a good case, the attorney will take it. They will get paid if they win, by the side who's bringing the case. So talk to someone. They'll let you know if you have a good case. But regardless, one of the ways that I've seen folks really be able to deal with this is by trying to settle it outright. Now, a lot of these cases are third-party debt collectors. So they've paid pennies on the dollar. There's going to be leeway with respect to what they will accept. Let's assume you owe $5,000, just to pick a nice roundish number. So the question is, what would they take? How much will they accept? So what I've seen is anywhere from like 25 to 40, 50% is a good place to kind of think about, I might be able to settle this. But it's not, hey, let me pay $5,000 and put me on a payment plan. No. If you want a payment plan, you're paying the entire amount, court fees, attorney's fees, everything. But if you want to get rid of it and you want to be able to take care of this debt in a good way, you're going to need to give them the money within 30, maybe 60 days, right? But a lump sum is what we're talking about. So if you owe, say, $5,000, I would start off at 25% of $5,000, right? That's where it's 20, 25%. You always want to start off low and then be willing to go as far as what, 40, 50%? I've seen them take that, right? FYI. But you're going to need the money up front. Now, you can do it before court. You can do it before your date for mediation. Just contact them and you make them the offer. A lot of times people will say, but how come they wouldn't do this before? Because before you were still dealing with the people who trying to collect the debt from the original, party who you took out the loan from or the unsecured debt from. But once it gets to this point, what they're most interested in is getting the money, and they will take less often. Doesn't mean it's going to happen a lot, but when people have cash and they can pay it then and there, you have a very good chance of doing so. So you can contact them beforehand, and if you come to agreement, first, don't send any money before you have the contract. Once you have the contract, then appropriately read it, review it, make sure it's good to go. If you need to show it to an attorney, do so. But then you sign it, and once you have then you make the payment. And then the question is, well, do I still have to go to mediation if I've settled it? Absolutely yes. The left hand and right hand, they don't always communicate. So who goes to the mediation is typically of counsel, not the attorney who sent it, not the the party down at home office who might be in Miami and I'm in Orlando. They're going to send of counsel, someone local, and sometimes they have no idea that it got settled. So you should then take that and contact the clerk and tell them, hey, I settled this. Here's the case. I'm supposed to come in this day. I'm sending this in to you. Do I still have to come in? Unless you hear absolutely not, everything is good, and you see that you're no longer on the docket, go in there that day and bring your contract and say, look, I took care of this. It's all settled. Because if you don't, then the attorney who's there covering, they have no idea, and they're going to try and get a default, and they will get it. And then you have to worry about, I can't tell you how many times I've seen folks, but I already had, now you have to get this default. What a pain in the butt. So show up if not. Now, most people don't do it that way, though. The smart ones try to do it that way. Let's say you're at mediation, right? But you have money and you want to settle this. That's what you do. You say, look, I want to settle this. I recognize so long as you recognize it's your debt and that's what you want to do, right? And you make them the offer, they will go outside, they will call the home office and they will say, look, they have cash and they say that they want to do this. And a lot of times they'll come in if it's enough, or they'll negotiate it with you. And then right then and there, your mediator, if you come to agreement, they will write it up, and you within 30 days, you're going to send a lump sum. I haven't seen them do more than 60 days, right? But again, you're going to need the cash. If you have the cash, though, it's a great way to get out of the debt, right? Get it taken care of, and you start working on your credit again. And you can settle debt really affordably that way. Those who try and those who have, everyone doesn't have cash, though. When you're at that position, a lot of folks, there's a reason they got there. And so if you don't have cash to settle it, you're probably looking at a payment plan. Unless, of course, you've contacted an attorney and for whatever, and there could be any one of a number of reasons, There could be defenses to the debt, is maybe the statute of limitations is passed. Sometimes a lot of times they don't have the original paperwork, and you're supposed, right, if you're supposed to have the original contract. But that kind of argument is typically left best for an attorney to make. Unless you know how to make that argument in front of the judge, you're probably going to lose. Just being practical, right? When you get in front of the judge, it's not like mediation. You have to know what to say, how to say it, when to say it, what not to say, and you should be practiced. Lawyers, that's what they do, and that's why you pay them. And if it comes down to, well, but I have to pay an attorney, the question is, how much is the attorney going to cost? How much is the debt? How much are you saving? You're probably better off going with the attorney. And that's a mouthful, I know, and there's a lot that goes into settling debt. You said hospitals. Hospitals are pretty good about trying to settle debt too, but you're going to contact them directly, and that's a case of a first party, debtor and the person the entity you entered into a contract with. They're in a stronger position than the third party. Although if they're an assignee of benefits, they're in a pretty good position too, unless you know how to defend against them. And it's not an easy thing unless you've done it before. It can be, quite sophisticated. Seek legal advice. But barring that, settling it, if you've got the cash, that works a lot.
Okay, Tye, thank you so much. And please explain once again, because this seems somewhat mysterious. Why is it so that at this very stage, the plaintiff, whether a third party or the original plaintiff, are really willing to settle the debt as opposed to before?
Yeah. So you stop paying your debt, right? And then where do you go? Collections. So the representative's job in collections is to get the money that you were given. It's nothing else. That's what their job is. They might be willing to do whatever that entity, whatever that company, they're going to have policies on, letting people pay back in certain ways. There's going to be fees. But typically what they're not interested in doing is in any way forgiving the debt that you owe them. They extended credit. They want to get paid back. So that's why at that level, when you're in collections, they're not really going to be willing to settle the debt, at 25 or 30 or 35, 40%. But after you're in collections for a certain amount of period, and it's something like 6 to 8 months, it'll vary by company to company. But then that debt, you go to a different level, or you go to a different place, or they'll send it to an outside, collection agency, and you might be there for a little while. A lot of times that their job is also not to settle it because they're still servicing a client's account, right? And so they are going to make money if they get the money from you. So the more they get, the more so their interest is still in collecting most of it. You might have some success there, but typically once the debt is written off, right? And so then that company is going to they're going to do it in a different way. When they do their taxes, they're writing it off. Then they sell that debt. And it is third-party debt purchasers who buy this debt, and they buy it for pennies on the dollar sometimes. And there's different levels of debt. The older the debt, the cheaper it is, but typically it doesn't come with a lot of the documentation, right? And the more you pay, these third-party debt collectors pay for the debt. If they want all of the paperwork to prove that they're the proper assignees, it's typically more expensive. And so it really depends on the kind of debt that your account has become. So once it's sold off, at that point, that debt collector, that third-party debt collector, they've purchased it, and they've purchased it at a really decent price. And so there's more, their profit is they don't have to make it all back. So if you owe $5,000, when you get sued, there's court costs attached to that. There may be attorney's fees attached to that, and all the interest, the entire original amount, they're going to put it all in there, and they have the right to seek it all. But because they're a third-party debt collector, because they haven't paid all that money, they're a lot of times very willing to, if you have the cash then and there, they're very willing to come to agreement, because really what they want is they want to they want to make their money back, and they want to make some profit on it. And so that's when people are in the best the best position to settle their debt, get everything off of their credit, and start to be able to move forward. And so imagine if you only have to pay, if it's $10,000, you only have to pay maybe 4,000, 5,000, something in there. That's not bad. That's a great way to take care of your debt. Yes, your credit, by that point, your credit's been affected, but your credit's already affected. And you can fix it well then if you've paid it off, because you saved money, and now it's going to show up on your credit report as if you paid it. And so you can start to move forward at that point. But again, you need the money. And if you don't have the money, what you're looking at is some kind of repayment plan, something down and something that you're going to pay on a regular amount, on a regular basis, the same time every month. And if you don't pay that, then however much you have paid will go towards what the debt is, and the rest, they will get an automatic judgment on that, because in signing your stipulation at mediation, you're agreeing to that, right? So it's quite fascinating, but there's a method to the madness, and it's just the practical way that it happens, The other thing is credit is a shell game. You either know how to play it or it plays you. And so, folks need to just do research. They need to read up on it. All of this is available on the internet. But you're never going to be wrong by getting a consultation, because the attorneys will love to hear from you, because they're looking for the kinds of cases that they can take and bill the party who's bringing the case against you if they didn't do it the right way. And they'll tell you, yeah, this is a great case, we'll take it, and you're not going to have to pay them, because they're going to get their fees later, or they'll tell you in short order if it's not a good case, but you're still going to get some good advice from them.
So we have about 3-4 minutes left. You already answered this question. What does a pro se defendant need to be able to settle the debt, and what percentage can they settle for you? I think you're talking about between 25% to 50%. That was in your experience. But could you say something about the fact that simply because you've experienced those numbers, that doesn't necessarily mean that viewers or listeners are guaranteed to get those kind of magical settlement rates, right?
Yeah, that's right. Look, it kind of depends on the entity who you have in front of you. Some of them, the good ones, the ones that I enjoyed working with, just come out and say, listen, we bought this debt, not many of them, but a few of them. And so we're only seeking half. That's a great place to start, right? But typically they don't do that. Typically they're going to seek the entire amount. Question is, what will they accept? And what is worthwhile to you, right? How much do you have, and how much can you afford to pay, and what will they agree to? So what I have seen is usually I haven't really seen anything below 20-25%. You're lucky if you can get that. So I would start off low. I'd start at like 25%, to be quite honest with you. But if you can expect that negotiations to come back, and they're going to be like, no, and but you start low, right? With knowing, well, I'll go as much as half. And so if you start at 25% is a great place. You have a lot of leeway between 25 and 50%. And so, even if though you wind up paying 50%, that's half of what you originally owed. And you can also, right, don't forget, you want to make sure, okay, but, just that amount. I don't want to pay court costs. I don't want to pay, any attorney's fees. You want to be sure to ask and make sure. I don't want to pay any fees. I don't want to pay any interest. This is the entire amount, and it settles everything. And so then you're coming off, you're still having saved money. You're still going to be able to start repairing the issue that is affecting you. Go and try and rent an apartment or a home. This bill is going to come back to haunt you. And typically they want to see that they've been paid before they're going to extend credit. Trying to get a car. I mean, any one of a number of things, right? And then if they get a judgment against you, right? Okay, no, they can't make you sell your house to pay a judgment. There's no debtor's prison. But when you sell that house, they can get the money from the proceeds, right? They can put a lien on some of your property. It may not work against a homestead property because there are protections, but when you sell it, right? And all they've got to do is whatever the statute says. Every so often they have to just renew that judgment. Typically they do. And so the best way to get out of it is to, one, know your rights, get legal advice. But if this is a debt that you owe it, you're gonna have to pay it. And bankruptcy isn't the option, right? Because bankruptcy is the option for some folks. Then you want to negotiate it away as best as possible and try it. Start at 25%. And I would say, what's your limit? If you think it's 50, then it'd be 50, but start at 25 and work your way up. And you need the cash right then and there.
Okay, thank you so much. And we're coming close to the end of the time that we are devoting to this, but can you quickly say if a pro se defendant is able to settle before mediation, and this mediation in this small debt claims is obligatory, do they still need to attend the mediation?
Yeah, you should go. Unless, contact the clerk, let them know, send everything in. You want to make sure that it's in the docket, right? And unless you hear from the clerk, no, you're good to go, you don't have to come in, you need to go. Because again, a lot of times the left hand doesn't know what the right hand is doing, and the individual who goes there to represent the debt purchaser or the entity that's bringing suit against you, a lot of times they don't tell them, oh, we don't worry about this one, and so that attorney is going to want to do their job, and doing their job means they're going to seek a default judgment, and they will get it. So show up unless you absolutely know for certain that you've sent everything in and you've been told by the clerk, don't worry, you're good to go. Go that day. It should be fast because you're going to have the agreement with you. You're going to show them, and then the attorney's going to be like, oh, I didn't know about it. And then they're going to make a call. Okay, we're good, right? But better that you're there, and then you don't have to deal with the aftermath, because if you're not there, you'll get it taken care of, but it will take you months. It will take you headache. You're going to have to submit. Just go. It's easier that way.
Thank you so much. And that would be it from us today with the topic, how can pro se defendants in small claims debt collection cases settle their debt for less than lawsuit amount? Thank you, Tye. Thank you, Mac. And I hope to see every single listener and viewer in our next videos in this series, Mediating with or Without Attorneys with Tye Bourdony. Check it out on Instant Mediations app, Apple Podcast and Google Podcast. See you then.
Take care.